Hello. I'm doing pretty good. You? Yes. I know you may hear this, frequently, but I'm positive if the DA would just look at the evidence, I think the charges would be dropped. Every bit of the evidence proves that I'm innocent. I could probably save you some time. I've actually constructed a video that it's the footage from the home security that captured the entire event, and it has some notes. Could I possibly just forward you a link to this video? No, I was not. I was pressured extensively by Cesar Almasi. He just would not accept anything except me taking the plea. Well, he assured me, and the way that he said it, it was very suggestive. He repeated, and he promised me that if I went to trial, I would lose. And he did it in such a way that, he almost winked while he was saying it. Like he assured me that if I insisted on going to trial, he would sabotage it. That was the impression that I got. Every time I would tell him that I had some evidence or anything like that, he would just shoot it down. He insisted that my home surveillance video did not show what I claimed it showed. He said that it showed other things. And quite honestly, I took the deal just so I could get out, get my hands on the evidence, and present my own case, because he just clearly was not presenting any kind of self-defense at all. I did not know the proper term to use. I didn't know castle doctrine was what I was looking for. I kept, saying to him, look, if I burn my dinner while I'm cooking and I leave my front door open to let the smoke out, and then I turn around and there's a pit bull in my living room growling at me, I'm allowed to shoot the pit bull and not get charged with discharging a rifle. And he kept assuring me that this isn't the Wild West, and no, that's not true, and there are no situations where you're allowed to discharge a firearm and not be charged with it, and that's just completely not true. Yes, she was outside the front door, but she weighs 400 pounds and she was beating the door down. So I shot through the door above her head to make her stop, and that almost was not enough to make her stop. It still took her friends to convince her to leave, even after that. And this is all in the video. See, that also plays into it. I called 911 reporting that I was being invaded. My home was being invaded. I said, I'm going to shoot these people if they come through my front door. Now, the only criminal history I have is about 20 years ago in Texas, I was charged with interfering with public duty. I basically refused an unlawful order. It's nonviolent. No felonies. I'm not a prohibited person. Now, when the police were responding, for some reason, the dispatch tells them that I am a prohibited person out of Texas and not supposed to be in possession of a firearm. So when they showed up, and I had no idea that they were misinformed, I'm trying to explain to them what happened, and they just weren't hearing it. All they wanted was to come in my house and get this rifle. And not explaining why or anything. They just kept saying, we need to come in the house and see this rifle. And I kept saying, no, you don't. And then in an effort to get them to quit talking about that, let's discuss this home invasion that I just stopped. I literally closed the door, went and got the rifle, opened the door, set it on the ground, and then went back inside. I mean, they would not quit talking about this rifle. And I, for the life of me, did not understand why. Well, it was because they were wrongly informed that I was a prohibited person. So they never listened to my side of the story. They never took my allegations serious. They just arrested me and completely believed the conflicting stories of the two alleged victims. I mean, their sworn statements are, yes, but it was one of the alleged victims that hired Damian Sheets. I didn't hire Damian Sheets. So, no, no, the alleged victim hired Damian Sheets. So I lost the public defender that I had. And then she reversed payment to Damian Sheets. So Damian Sheets recused himself. And then I had to go back on. I got the public defender again, but then there was a conflict of interest with one of the other of the three alleged victims. And then I ended up being on Cesar Almasi. And from day one, he just would not, I don't think he's ever even heard my whole side of the story because he's never let me finish. He read the DA notes, assumed it was all true, and that was the end of the story. Yeah, but he insisted that the video did not show any of the things that I said it would. Now, at that time, I hadn't had an opportunity to review the video, but I knew what happened, and I knew the video captured it. And the things I told him, to be honest with you, I haven't discussed anything with Caesar because he just would not discuss anything. It was take the deal or nothing. And then after I got out and I learned about the castle doctrine, I even asked him specifically, can you counsel me on the castle doctrine? And he never even answered that. I don't understand. I mean, I've spoke to 3 other attorneys since I got out. All 3 of them indicated they know Caesar. They said that he was a good attorney and a good man, and they didn't believe what I was saying. And when I showed them the evidence, they just couldn't explain why he was doing that. So, because they want money. I am desperately trying to sell my house. I've actually got my house sold, but there's no way that I'm going to actually get the funds in time. Well, let me send you a link to the video so that you can see it. I honestly don't think it. Well, not only that, he did not investigate this case at all. I know he indicates that he watched the video, but that's really not possible. If he watched the video, there's no way that he could continue to claim that it does not show I was defending myself. I mean, it clearly shows premeditated home invasion. They disabled 2 of my cameras before they did it. I mean, why else would somebody do that? But part of what was motivating me was I did not have any kind of assurance that it would not be treated as a felony. And the DA is under this mistaken assumption that I have an out-of-state felony, that I'm already a felon. And Caesar would not do anything to get that corrected. He wouldn't even ask the DA what he was referring to. I've since paid for my own background check, and nothing comes up that explains what they were referring to. It's almost like they pulled up the wrong person. And the respondent, I did. They did. At my bail hearing, the DA mentioned that I was a prior felon, and he demanded that I not be released on bail. I mean, this mistaken past felony in out of state has poisoned this entire case, from the responding officers not listening to me and arresting me to the DA demanding that I not be granted bail. It does make me feel better. Well, it wasn't just a matter of a couple $1,000s. It was $60,000 that I was quoted. It was insane. Which, I mean, I could do it. I did. well, no, it wasn't just a motion to withdraw. It was a motion to withdraw and then trial. Okay. Let me send you the video, just so you understand the gravity of the evidence that I'm referring to. Can I have your email address, please? Okay, I'm going to send you a link to a video. Now, the video it's over an hour long, but the actual I can, yes, I can. And I will take everything that you've said, and I will give it some serious thought. You've certainly given me more hope than I was getting from Caesar. I wasn't getting anything from Caesar, so my mind was kind of, okay, okay, okay. I thank you. Hello. Well, I could go ahead. Okay, I will pull it down. Um, well, as far as the big girl at the front door, my view from inside was she was beating that door down. Every time she hit it, I could see light all the way around the door, including the hinge side. If she succeeded in knocking that door down, I would have had to shoot her. So I thought shooting through the door would make her stop, and it barely did. I mean, it did, but um, okay. Um, okay. Thank you. Yes, Sue. Hello. I apologize. I don't mean to be hard-headed or anything. It's just so difficult to believe that that's how things go down. That a mistake isn't that they don't go backwards at all, even when they realize that a critical mistake was made. Okay. Okay. Um, I certainly hear what you're saying. I did quite a bit of research on you before contacting you. You're very respected. I totally trust everything that you're saying. Uh, okay, could we do that? Could we do whatever we can to stretch this out? I've actually got a. No, I didn't mean to suggest that's what I meant. No, I mean, I'm trying to sell my house. I've got a buyer, and my intention is to hire Peter Bellin to take it to trial and just get me off of these charges. But there's no way I'm going to make that. I'm going to have the assets from my house in time to retain him, or even by the first, as was originally the sentencing was on December 1st. Okay. Well, I've already sold it. I can't back out now. I mean, I've already. Um, right now, yes, I do. Whether I'll change my mind in a day or two, I'm not locked in my decision. I mean, I'm thinking about it. I'm giving everything that you said uh, serious thought. Um, okay. You too. Thank you.
staff, Mr. Sykes and Mr. Troiano. Currently on blue team is myself, the judge, district court moderator, who I assume is the JEA, Kristen, who is the court clerk, Jessica Mason, who is the backup clerk, and Tamara Watkins, who is my law clerk. So everyone is here except for court staff, Mr. Troiano and his client. So Mr. Troiano, go ahead.
Your Honor, as the court's aware, Mr. Al-Bassi was on this case. It was pled, and the defendant then said that he wanted to withdraw his plea. I accepted appointment on that. I've had 3 phone conversations and an in-person conversation with Mr. Sykes regarding that. My ultimate opinion was that, based on what he told me, that there was not a good faith basis to withdraw the plea. But several things that have been said and done by the defendant since then have led to me cause to concern. I'm not really sure where to go with it at this point, because I believe it would be breaking attorney-client privilege to, I guess, further explain that. That's kind of when I threw out the off-record thing. I know that's unusual, but I guess I need some guidance from the court here, because we could make it as simple as, based on what he's told me, I don't find a good faith basis, and then the court can make a ruling on that. If not, if there's going to be additional things that need to be addressed, for me to specify exactly what I'm concerned with here, my difficulties presenting this information to the court, I would ask for some guidance.
I'm fine, and if Mr. Sykes is okay with waiving his attorney-client privilege, it's just that, who is this in the back of the court?
Hold on. My name is Greg Hess. I'm helping him sell his home.
And you're his wife now?
Is retired.
Close enough.
I thought the courtroom was clear for this.
So, there are parties here for Mr. Sykes. I'll send them out.
If it's Mr. Sykes' family, then that's fine.
Can I request that they stay?
Okay, so, Mr. Sykes, if you're okay with waiving attorney-client privilege, then we will just, make sure that this, hearing is not transcribed, and, we can go forward with that. Mr. Sykes,
I don't have any idea why that would be the case, and this man won't speak to me. He's acting like he doesn't see me. I don't understand why he's doing that. He appears to be a decent attorney.
Mr. Klaus, we're in closed hearing right now.
I apologize, Your Honor. I'll be leaving right now.
Thank you.
Why won't you speak to me? This is not... Is this normal for an attorney to just act like he doesn't see his client?
Mr. Troiano, I'm not really sure what's going on right now, but I would like for you to give me a little bit more information so that I can try and...
Sure, I'm happy to. I just wanted to make sure, has he officially waived his...
No, not. No.
Okay, then I can't make further representation.
Well, can we step outside and you explain to me why?
I'm not comfortable with speaking to him based on what's been happening, and I can't waive my privilege to fully explain what exactly has been going on. So all I can say without waiving privilege is that I do not believe, based on what he's told me regarding the actions of Mr. Al-Massi, that there's a good faith basis to withdraw his plea. It's as simple as that, although not really, because there's more, but I guess it's not necessary. The court can make a ruling on that.
Your Honor, I am selling my house to hire a private attorney to defend me because these guys won't. I don't understand why they won't. There is a 10-minute video, if you could just watch it. It shows everything that happened. My home was being invaded. I called 911 for help.
Stop talking.
Yes, ma'am.
Mr. Sykes, I would like to have some additional information. I would like for you to please, it is unusual for him not to talk to you, and I'd like to have more information. I'd ask for you to waive the attorney-client privilege so that I can get more information.
Is that just for this meeting?
Just for today.
Okay.
Thank you. May I go forward, Your Honor?
Yes.
Judge, as I've stated, I believe I've had 3 phone conversations with Mr. Sipe as well as an in-person phone conversation. I've explained to him what the parameters are of a motion to withdraw the plea. Mr. Sipe, like many people who are in this position, wanted to start relitigating the case from the beginning. So I did what my job is, which is I educated him to the best of my abilities to explain that we're not quite there yet. We need to get to whether he knowingly, intentionally, and voluntarily entered his plea and what happened between him and Mr. Almasi, because the judge needs to make a decision whether there is a, I need to make a decision, first of all, there's a good faith basis, based on what he tells me, to file said motion. And Your Honor needs to make a decision on whether there's enough to either have an evidentiary hearing or make a ruling one way or another. We had that conversation in depth. He explained to me that Mr. Almasi winked at him and he felt that that was a threat and that he was forced to sign it. When I explained I didn't think that that was viable, he then said that, well, he only signed the plea so he can get out of custody. I then warned him, even if he got what he wanted, and I didn't believe that was a basis that Your Honor already stated on the record, he would go back into custody because that was part of the plea agreement. We finished the conversation. I told him to, I pretty much have what I needed, but I wanted him to think about it because as many people that are in this position, they're very emotional and upset. We had another phone conversation, I don't know, a day or 2 later. Same thing, we're back to square one. He wants to relitigate the case. He sends me the video. I watch it to appease him, discuss some things that, again, aren't necessarily part of what Your Honor would decide for a motion to withdraw a plea, in my opinion. He posted the video online with sound effects, superimposed words, almost as a cartoon. I advised him to immediately take that down. I had concerns regarding that. And then each conversation just continued to devolve into the same issue. He then stated that he was selling his house and he met with an attorney who quoted him $60,000 to file this motion and then proceed to trial if granted. I said to him clearly, as generally my practice, the majority of it is as a private counsel, although this case is appointed, I would never be in the position to try to take money out of one of my colleagues' pockets. And if he met with an attorney and quoted him and he wanted to sell his house to hire a counsel of his choosing, he'd be allowed to do so. Furthermore, that made me believe that he may not even be eligible for appointed counsel due to not being indigent at this point. I also tried to have a heart-to-heart with him and just said, listen, I don't know you, you don't know me, but $60,000 is a lot of money. You got very minimal prior criminal history. I think that this court would grant or would sentence him under the gross misdemeanor statute, and that he would receive probation based on what he told me. Again, outside of my purpose, but doing everything I could to provide him the information regarding what we have going on here. He took that into consideration. No, I want to hire a new counsel. We spoke outside the court last time. I told him very clearly, based on what Your Honor stated, because I had a previous issue with Judge Miley where I explained to her that I did not believe a client had a good faith basis to file the motion, and she said, well, essentially file it anyways, and she made me have my client sign an affidavit, so I wasn't in the position of filing a good faith, a motion that was not in good faith. Your Honor advised that you did not believe that that was necessary or appropriate, and it was my sole decision on whether to file it. I explained that to him in the hallway, and just told him, hey, you got 1 or 2 choices here. I don't find a good faith basis, but you're telling me you're selling your house. You're telling me you got $60,000. If you want to hire your own counsel and you met with this person and based on their information, they believe that there's a good faith basis, that's fine. Attorneys have different opinions. So if that's what he has, he's welcome to do so, and that he would need this person to be appearing at the next court appearance. We left it at that. Several days later, I get an email with an attorney CC'd on it, which, in my opinion, was clearly written by the attorney. It's almost threatening in nature, the way in which I read it, which makes me uncomfortable to speak to him because he's putting words in my mouth stating that you told me in court that you're not going to do anything and that I need to hire my own attorney, when all of this was his idea, his words, his verbiage, his propositions. I don't know who this attorney is. I didn't respond because I don't know if he hired him. I don't know if he violated privilege at that point. I wasn't sure if that attorney was going to come here in court. And Your Honor's been in front of me. I've been in front of Your Honor many times. I've been doing this 13 years. It's not too often it gets to this point. I deal with a lot of people with many different personalities, drug addiction, mental health issues. This is unusual and strange, and I became very uncomfortable with the way that this was going. And then I believe last night, he probably realized that he erroneously CC'd that attorney who I'd imagine wrote that email and then resent an email to me last night without that attorney CC. I'm just in a very, very awkward position here, Your Honor, and that's the entirety of my representations.
Mr. Stipe?
Wow. That is not an accurate representation of how those conversations went. I have a provable self-defense claim, and Cesar Almasi refused to present that defense to the court. He insisted that the evidence did not show what I claimed that it would show.
Mr. Stipe, that's not where we are right now.
Where are we right now?
You have signed a guilty plea agreement. The only thing that I'm here to determine, not whether you had a viable self-defense case, whether or not you knowingly and voluntarily signed that guilty plea agreement. That's what we're here to determine. Mr. Troiano is saying that he doesn't have a good faith basis to file a motion saying he didn't file it, he didn't sign it knowingly and voluntarily. It doesn't, to me, sound like he does have a good faith basis for that. So tell me what the basis is for you signing that guilty plea agreement. That's the only thing we're here to tell you.
Cesar Almasi explained to me that the evidence incriminates me, and in my opinion, it exonerates me. And he assured me if I went to trial.
Hold on, Mr. Stipe.
Yes, ma'am.
Can you please stand at the plaintiff's table closer to the microphone because I need to hear from both of you. And I can't hear you all the way, so stand right in front of the microphone. If you please just limit it to why you signed the guilty plea agreement.
I signed the guilty plea agreement to get out of jail.
Okay, that is not a good faith basis to withdraw your plea.
I am at risk as far as COVID. I've got unexplained skin cancer, recurred 3 times. Nobody in CCDC is following mask guidelines. They give the inmates 1 mask per week.
Precise. If the negotiations were for you to get out of jail, and that's why you took the negotiations, then you don't have a good faith basis to withdraw your plea. You made a decision. It might be a decision that you don't agree with now, but you made that decision. You made that decision knowingly and voluntarily.
I made that decision under false information from my public defender.
You made it. You just said that you made the decision because you wanted to get out of jail. You got out of jail, so that you made the decision that you wanted to make. So
I felt I didn't have a choice. Cesar Almasi would not. He would not defend me. He wouldn't present the evidence to the court. He didn't investigate the case at all.
Sir.
Yes, ma'am.
You wanted to get out of jail. You did get out of jail.
I shouldn't have been in jail to start with.
That's not a decision that has anything to do with whether or not the plea was freely and voluntarily made. That plea was freely and voluntarily made because you made it based on the choice that you wanted to do. You got the benefit of your bargain.
I was told not to tell you. Okay. I was told by Peter Bellin not to repeat what I told him. I signed the deal so I could get out and investigate the case myself. And I've put the evidence together. Cesar Almasi wasn't investigating the case at all. He was just...
You signed the deal because you wanted to get out of jail. You got out of jail. So that was a reason to sign the deal. It was a free and voluntary reason to sign the guilty plea agreement.
I guess legally, yes. Okay.
Okay, I find that there is no reason to withdraw the guilty plea agreement. I do find that there's probably been a breakdown of the attorney-client relationship with Mr. Troiano as well. So I need to set this for sentencing, and I need to set it with Mr. Altig as the last choice unless you hire somebody.
Your Honor, if I could just interrupt, I understand that, my representations today are highly unusual. With that said, if Mr. Sykes not going to retain counsel, I'd rather not put this, usually, in my experience, when the motion is denied, it goes back to the originating counsel, which would be Mr. Obasi. That's been my experience. But I understand the issues with him. I'd rather not have to place it on Mr. Altig. I'm fine staying on, even with all of that, if we're strictly dealing with sentencing, because that's one thing that I've been very clear with him, and what I've seen and what he's given me is that based on my experience with Your Honor, the facts of this case, lack of criminal history, that I cannot guarantee, but I am confident that he will receive gross misdemeanor treatment and probation. I feel like I could come in here and strongly recommend that and argue that to the court on his behalf. So if you're gonna deny it and just set this for sentencing, if the court's comfortable, I would be happy to stay on absent this, because we're just not going to discuss it again. We're going to move on to sentencing, and that's going to be it.
Mr. Troiano, are you sure? Because it sounds as if, normally it does go back to the attorney who had it, but it sounded to me as if the attorney-client relationship between him and Mr. Almonte was beyond repair, and I thought that yours might be as well.
Your Honor, I've sold my house. I've got my realtor here in case you think I'm disingenuous. I contacted Peter Bellin, but unfortunately it was after Thanksgiving. He's not taking any new clients until the first of the year. He asked me to ask for a continuance until after the first of the year. Please.
Your Honor, I'd be prepared to go to sentencing as soon as next week if you'd like me to stay on.
Mr. I don't remember, do we have a PSI on this one? I'm just looking, I don't remember.
The PSI shows that I only one nonviolent misdemeanor on my record. Up until this point, everybody's been under the false belief that I was a convicted felon, prohibited person, not supposed to have a rifle. None of that was true. It was based on that they arrested me instead of the people invading my home, which is on video. 10-minute video. All you have to do is watch it. Yes, I added cartoon sounds to it. It's a very...
Mr. Sykes, we have a PSI. We're going to go forward with sentencing. Mr. Troiano, I'm not here next week, so we'll do it in 2 weeks.
15th of the month? Okay.
That'll be December 15th at 9:30 for sentencing.
Okay, thank you. And can somebody
I'll text her, Your Honor.
thank you, Mr. Troiano. And I just want to make the record clear, there should be no transcript from today's hearing. I don't know if there's a way that you can publish records from JAB. I don't know if there is. If there's something that I need to sign to make it, to seal it or anything like that, please let me know.
Yeah, we can seal it, but, yeah, we can seal it.
Okay, thank you, Susie.
You're welcome.
And that's everything I've got for the calendar.
Thank you, Your Honor.
Thank you, Mr. Troiano. Good luck to you, Mr. Sykes. you. Mr. Troiano, what do you have?
I have wood and site.
Are either of them here? Oh, Mr. Syed is present, okay.
Mr. Johnson, I'll call you.
Case number 14, State of Nevada versus Mr. Syed is present in court. Come on up, Mr. Syed. Mr. Troiano, present by Ms. Overly, assistant to the state. Thank you, Ms. Overly, for the state. This is on for entry of judgment. This is a sentence and there is a legal cause or reason to not proceed today.
Your Honor.
Mr. Syed, by virtue of your plea of guilty via the Alford decision, you are hereby adjudged guilty of the offense of attempt battery resulting in substantial bodily harm, a category B felony or gross misdemeanor. Ms. Overly, my understanding is the state has the right to argue as to whether or not this is felony or gross misdemeanor, but has no opposition of probation.
And that's correct, Your Honor. At this point, I recognize that the defendant only has one prior misdemeanor, which appears to be from 2006. But the underlying facts of this case are somewhat alarming, obviously, in that the original charges stemmed from an attempt murder, discharging it into a structure. This involves him firing at least 2 rounds of his rifle at both victims in this case. I think it's concerning in that he could have clearly injured other individuals who are also in the area. So, I mean, I think that this is a situation where he's already getting the benefit of the attempt battery was substantial, provided that he was barely, based off of the report, he shot a rifle through the door, barely having missed the victim in this case. So, but not for, pure luck, he could be here on a murder case. So I think that a felony would be appropriate, and so I'll submit it on.
Thank you. Mr. Syed, your attorney is going to have an opportunity to speak on your behalf in just a moment, but is there anything you'd like to say?
Can I speak after he does, please?
Oh, you want to go after? Okay, Mr. Troiano?
Sure. Your Honor, as the court's aware, Mr. Almasi initially had this case. He negotiated it. I was brought on for an emotional withdrawal plea. If you recall, we had a lengthy hearing on that outside the presence of the DA regarding some of those issues. What I can say is, though, when you look at the pre-sentence investigation report, yes, it is one prior misdemeanor, so he essentially has lived a very normal, productive life without any sort of criminal history that would bear on his sentencing today, in my opinion.
Mr. Troiano, here's where I am. I mean, and Ms. Overly as well. This sounded like he's trying to defend his home. It sounds like these people are coming into his home and he's shooting. I mean, I understand that it's, his ex, but they didn't have any right to be in his home. And so to me, that doesn't necessarily warrant a felony.
And, Your Honor, I'll be brief. Sounds like we're in the same position. And that's where I was going. I got the opportunity to watch the video. Unfortunately, Mr. Syed was more interested in drawing the plea, and there really wasn't a good faith basis for that. But when I did get an opportunity to watch the video, I do agree with you. 2 individuals broke into the back of this house. They were not welcome guests. They went right through the back door. That's when he shot. I think where he possibly got a little bit further than he should have is when his ex-girlfriend is at the front of the house after these 2 individuals try to break in, and she's pounding on the door, and he shoots through and above her. Again, I think it could have been defensible from the very beginning, but unfortunately that's not the case for him. He did enter his plea, and yes, I think that a gross misdemeanor treatment based on all of the above and probation is warranted in this case.
Mr. Syed, go ahead.
There are a couple facts that are, I feel it's important that you know.
Before you start, can you please put your map over your nose, sir? Not be over your head.
Come on, man.
Go ahead, Mr. Syed.
Under the section for childhood, family, that is, that's accurate, but it's missing a lot. When I was 15, my mother killed my father, cold-blooded murder, stood in this very court and got away with it by claiming fictitious domestic violence. His funeral was on my 16th birthday. Under the section for education, it says that I graduated from Western. I did, despite what had happened. I was a straight A student, and the only way I was going to make it to college was on a scholarship, and I got an academic scholarship. Criminal record, like you said, 1 misdemeanor. The arriving officers were advised by dispatch that I was a prohibited person convicted out of Texas and not supposed to have any firearms. So when the officers showed up, there's no question they're arresting me, but I didn't know that. I called 911 for help when my home was being invaded. Help didn't get there in time. I fired 2 bullets up to repel these people. I could have used deadly force, not restrained. Cesar Almasi would not press the DA on where that information had come from, why they were told that. He wouldn't do anything to correct the matter. At my bail hearing, the DA brought up my violent past and my prior convictions when he argued that I had not received bail. I was denied bail.
No, can you close that door? Because people like when you're on court.
I was denied bail. And now finally the PSI's here, and it shows I am not a prohibited person, and I was rightfully in possession of that rifle. But I had no idea that they had been told that. And they, of course, assuming that I'm a prior felon, that I surely know I'm not supposed to have this rifle. So they were playing games with me. They're just trying to keep me calm, telling me that everything's fine, you know, we're not going to arrest you. We just need to come in your house and see this rifle. And they just kept saying that over and over. And then they'd look at each other and they'd take one step closer. And I, for the life of me, could not explain why they were acting this way. That's why I went inside. They wouldn't give up on coming in my house and seeing this rifle. I said, fine, I'll give you the rifle since it's so important. So I went inside, I got the rifle, I brought it out to them. When I brought it out, they're gone, you know. Anyways, so, I mean, the way that they describe it, or the way they explain it, is very misleading. It indicates that they received a call from the victim. I called first, and they're completely leaving that out. I called 911. It said that these people were invading my home. I'm going to shoot them if they come through this door. And then they came through the door. So instead of shooting them, I shot through the roof. It was actually an accident. But I didn't mean to shoot it, but it went off. And that made them run. They retreated. I'm getting too in depth for you. Yeah, I called 911 first. Under on page whatever, next page, it indicates that
We don't actually need to go through every page of the PSI.
well, there's errors on every page.
Okay. I mean, it sounds like there are omissions, not necessarily errors, so.
Well, okay, it says that the defendant has also been convicted in Nevada of the following misdemeanor offenses: interfering with public duty. That wasn't in Nevada, it was in Texas.
Okay, well, again, we're fine, we don't need to go through every page of the CSI, Mr. Sykes.
Okay.
I mean, I'm fine with you talking about the facts and everything like that, but we don't need to go through the CSI. We can talk about, like I didn't interrupt you on your life, because that is important. That is important. Your recitation of the facts, those are important, but whether it was Nevada or Texas.
Well, that was just an example of a non-omission error.
Okay, but I mean that.
You know, the courts are backed up. You guys are busy. Part of the problem is what I'm sitting here doing. When my so-called attorney was advocating for me just now, you indicated that, you know, this looked kind of like it was maybe a home invasion and not what they're spinning. I'm just going to leave it at that. I think you see what's really happened. And why I've made it this far is unbelievable.
It's an Alford plea. I mean, and so that to me says that you're not saying that you did what they did, but you didn't want to face higher charges. So
I was assured that I would face higher charges.
you were facing higher charges. You were actually facing higher charges. So that is not just an assurance, that's actually the truth. So, Mr. Syke, in accordance with the laws of the state of Nevada, this court assesses a $25 administrative assessment fee, a $150 DNA fee, a $3 DNA administrative assessment fee. This is going to be, you're going to be sentenced under the gross misdemeanor portion of this statute.
Thank you.
And this is not a felony, so this is going to be a gross misdemeanor. You are hereby sentenced to 6 months in the Clark County Detention Center. That is going to be suspended for a probationary period not to exceed 6 months. It is going to be informal probation, so all you've got to do is stay out of trouble and come back here in 6 months and show me that you did stay out of trouble. I have 115 days credit time served. So we need a status check.
What, Charleston?
No, we need a status check.
June 15th, 2022, 9:30 a.m.
Thank you. 11, State of Nevada versus Shane Site, case number 2-1. Mr. Site is present in court, Mr. Troiano is also present, and Ms. White for the state. Mr. Troiano filed a motion to withdraw as attorney of record. Here's the only issue is that he's only on informal probation and we've only got a status check. So I just want him to have somebody to represent him at the status check to make sure that everything is, you know, all he's gotta do is stay out of trouble.
I understand that, Your Honor, and if you want further detail, I've tried to keep the motion plain. I know you were here before. If the court recalls, you encouraged me, and I wish I would have taken your advice just to withdraw then, but I wanted to clean this up. But there's been some things that have occurred since then that absolutely I could not stay on for the most minor of court appearances. If the court wants me to go further into that, I don't think we need to. It's essentially post-conviction at this time, which I don't believe is an entitlement to counsel.
Ms. Wise, I'm inclined, there have been some issues through the whole thing, so I'm inclined to grant Mr. Troiano's motion. All it is on for Mr. Site is for you to just stay out of trouble and you come back to court on June 15th. That's all you need to do.
I can certainly stay out of trouble.
Right. So yeah, so just come back to court, stay out of trouble and come back to court on June 15th at 9:30, okay?
Thank you.
Your Honor, I haven't had effective assistance of counsel from the very first day.
Mr. Site, you're already adjudicated guilty. Literally the only thing you have to do is stay out of trouble.
These people that were invading my home after I was arrested, they stole everything that I owned.
Mr. Site, for this case.
Okay, well, I can't get the police to even take a theft report because of this.
I'm not the police. All I need you to do for this case is to come back to court on June 15th and show that you've stayed out of trouble, okay?
This is going to negatively impact me for the rest of my life. I'm never going to work in my field again.
You've got a gross misdemeanor, Mr. Site. There's nothing else I can do.
Your sentence was very lenient. I am very thankful. It could have been so much worse, but I didn't do this. And taking a guilty plea is...
Mr. Site, this is not what we're here for right now. If you'd like to see if you can withdraw your plea, you need to hire somebody.
Nobody will even take this case now for all the money in the world. Nobody will touch it.
That's exactly. So there's not anything else I can do, okay?
Thank you.
Thank you. I'll see you back here in June.